Now, when we're talking about common law jurisdiction, we have to have a loss of life, liberty, or property. Now we come to the subject, now that we've taken a look at the jurisdictional brief. Here's your brief. Here's your issue. There's no loss of life, liberty, or property, so therefore this court has no jurisdiction over me. All right? There's the issue. Now, in support of the issue, we have to have our argument. And the argument is, why is that so? Let's take a look at the jurisdiction brief called Merchant at Law and Supply of Demand for Dismissal. Let's take a look at this one next. Merchant at Law, which is a jurisdiction brief. And now we're going to tell the court from the common law why it is that this court doesn't have jurisdiction based upon my particular circumstance. I'm a merchant at law. What is a merchant at law? And how does a merchant at law function? Let's take a look then at what a merchant at law is, how he functions, and why it is that our common law is no longer functioning, and why when you walk into a courtroom they're called courts of law, not courts at law, and why there has been a merger of law and equity. Let me make this bold and brash statement, and then let's take a look at what our Congress did in 1933 with our gold and silver and with our money. The common law is inextricably tied to property or land. That land is convertible to gold and silver. When you walk away with gold and silver, it's convertible back to land. When the Israelites crossed the Jordan River, they were the first persons or people or group or nation of persons who walked across, picked up some real estate and said, this is mine, and put boundary markers out, and it was against the law to move a man's boundary marker. And in the Jubilee year, that land always reverted back to the original owner. It went back to the family to which that land belonged. Now, there's something about that that's unique and different that no other nation, no other group of people have ever adhered to except the Western democracies or the United States, Canada, Great Britain, South Africa, Australia, etc. Those countries claim, and the people of those countries claim the land. In Russia, there's no misunderstanding about who owns that steel mill or who owns that land. In the United States, we claim ownership, but we don't really have ownership. And we haven't had ownership of our land since 1933. You are a feudal serf on the government's land, and here's why. The accused, then, can find no other term to define his status as a free and natural citizen than that of a merchant and trader at law on a cash basis. Merchants and traders, for this application, share one trait. They both deal in goods and merchandise in their business transaction. The unfortunate fact is that since 1933, we Americans have all been compelled to speculate on the value of the Federal Reserve note, or more specifically, evidences of choses in action for currency or cash. Not having recourse to the standard gold dollar, lawful money, which comes to us from the Coinage Act of 1792, with it standing in the common law as payment. You see, the common law is supported by being able to pay your debts at law. Today, you don't pay your debts. You tender your debts. It's like a game of old maid. You've got a Federal Reserve note that you took and you gave for it goods and services. And now, in order for you to replace that, chosen action, in order for you to get something for that piece of paper, you've got to pass that fraud off to someone else. The use of choses in action as legal tender for debts is but traffic or commerce in bids against the goods and services of America's market, compelled upon us by act of Congress in the form of House Joint Resolution 192 from June 5, 1933, which suspended the gold standard and placed a moratorium on the payment of debt. Now, the average guy out on the street says, so what? Big deal. Well, the big deal is that you just lost your rights when you lost your right or your absolute duty and obligation to pay your debts at law. You now tender your debts in equity. And in fact, you don't pay any debts. You don't pay for anything. The Federal Reserve then, as a consequence, owns everything in the nation because theirs is the only money. It's a system of private money. There is no public money at law. So we've been then effectively reduced as merchants in equity. You are in fact a merchant and trader in equity, unless you claim your right to be a merchant and trader at law. To state then, as the accused has, that one is at law, is to repudiate such acts of Congress and resume the status of the common law, even though one cannot pay debts at law with lawful money of the United States. When I walk in that courtroom, I make the statement and the claim that I'm a merchant and trader at law on a cash basis, and that through no fault of my own, my government has illegally and unlawfully reduced me to a feudal serf or tenure, a tenant on the land. And I absolutely repudiate that. You can't create in me, you can't cause me to give up my rights. I have to do that voluntarily. And I'm in here to tell you plainly that I'm not volunteering. A free and natural person is without recourse to such money of account, and he uses the nearest cash substitute for all transactions. Therefore, the status of merchant and trader at law on a cash basis. If I had gold and silver, I'd deal in gold and silver, but because, and through no fault of my own, my government has taken it away from me, I'm using Federal Reserve notes because it's compelled upon me. Congress created by the people through the Constitution is without power to overthrow the common law of Article 1, Section 10 on tender or contract, nor the Bill of Rights, which serves as the people's further restrictions on government. You see, government does not have the capacity. Government, the Congress, does not have the jurisdiction to repudiate or rescind the Constitution without a two-thirds votes of Congress and a 75% vote of the states. And yet they have done that by a simple House Joint Resolution in 1933. But they didn't compel it upon the people. They just said, we're going to do this, and the people lined up at those commercial banks and turned their gold and silver in voluntarily. Those people never asked the question, what are you going to do to me if I don't give you my gold and silver? So here's the people in 1933 giving their substance to the bankers and taking the bankers' promises to pay. And they all did it, and they all did it voluntarily. The accused then feels compelled to notice to the court that where I am, let's see if I've lost my place. These further restrictions on government. Let's start in the middle of that paragraph on page 2 where it says, acts of Congress which affect a derogation or an outright overthrow of a citizen's status are patently unconstitutional and void ab initio. Nor can any court of the state compel such an implied contract upon citizens at the common law. Boy, those are powerful words. Now let me explain that to you. We're saying then that the Congress has no jurisdiction to take away from us our gold and silver coin. They didn't do that. We did it. We lined up at those banks and we gave it away. Citizens aren't out demanding gold and silver coin from their representatives. They don't even know that gold and silver coin is important. But without gold and silver coin, there is no tie to the common law. And that's why we have equity jurisdictions in all of our courts, because you don't have any way to pay your debts at law. Now, I know that's a little complex and it's a little hard to swallow at first blush, but by the time we get through this, I think you're going to understand why it is that our common law has been done away with. It's been done away with not because we voted it out or the common law has been superseded or voted out of our lives or something. The common law is there and it's stuck there because the Constitution is still in full force and effect. But we're not using it. We're not claiming it. We're not demanding it. We're not that belligerent claimant in person who walks in the courtroom and makes his demands at the common law. The accused then feels compelled to notice the court that the accused claims this status, so rare today but absolutely imperative and pertinent to this case. How this affects the court's jurisdiction in the area of the person and the ability of the court to effect a remedy are as follows. Here comes your preventive or your penal remedy. Here comes your contract. You see, Here's what happens when you go to a bank. You got a check, or you've got gold and silver. Gold and silver is property. And the people took the gold and silver into the bank, which was their property, which was an absolute allodial or allodium right. It was the tie to the land. It was property. They gave it to the bank, and they deposited it, or they exchanged it for a paper note. The paper note is a promise to pay. They gave up title to property for an equitable interest in recovery of the property. So the property title, ownership, moved to the bank, and the person who turned in his property, his allodial right, got an equitable interest in the property and a right to recover. Master-servant relationship. The master holds the gold, and the servant holds the claim by which maybe the master someday will make payment. And so we all reduced ourselves to the status of serfs on the bank's land. Now, who owns and controls the banks? They're all corporations, and so the sovereign legislators, the sovereign states, own the banks. You know, in the Soviet Union, they're not hypocritical. The state claims to own the land, and the state claims to own that steel mill. In this country, we like to say that the land belongs to the people and it's in private ownership. That's poppycock. You show me any allodial land in the United States. I happen to know of 10 or 15 pieces of allodial land in the United States, and all land is basically allodial, but now the banks and the mortgage companies all have title to that land. And all we the people, all we're left with is the equitable interest. So we're all in equity. Why would anybody in equity go into a court and claim his rights at law? Because there aren't any rights. It's a contractual interest. The bank has the gold and the silver, and they're the master. We're the serfs, we're the tenants on their land. And what we do here is we claim that we're landowners. We're not landowners. We are people that have equitable interest in land. And our government, take a look at it. Doesn't the EPA tell the steel company how much smoke they will emit? Doesn't the Department of Labor tell the steel company how much they will pay? And doesn't the Department of Commerce send out letters and demands upon businessmen to fill out these forms and tell us and let us know how much your business is? And doesn't the IRS come in and audit your books and records and make you pay taxes? There isn't anything free about business in America today. Now, there may be a few merchants and traders at law that are operating out law under the Constitution and are free from that kind of harassment, that there's 1 in a million. And I dare say you're probably not one of them. Congress created by the people through the Constitution is without power to overthrow the common law of Article 1, Section 10. Only we could do that. No constitutional amendment has ever been passed to overturn or overthrow Article 1, Section 10. And yet common law, well, I shouldn't say common law, but people who are claiming common law rights are going into the courts screaming and yelling Article 1, Section 10 off point. And they're off the wall and out to lunch, to coin the vernacular, because a man who is in the banking system can't go into the courts and scream common law rights. You don't have any common law rights. All you have is choses in action. You've got Federal Reserve notes. You've got an equitable interest in the property, but the bank has the property. The bank has the gold and silver. You don't have that. So until you can get rid of your checking accounts and your bank credit cards and pay the mortgage off on the land that you have an equitable interest in, you can't claim to be a merchant and trader at law. Now, you can become a merchant and trader at law. You can come to the common law, but you're not there yet. You just want to get there. So down here then, here's penalties and penal remedy. Jurisdiction is derived from power and capacity. The fines ordered by the court in traffic cases are payable or tendered only in the form of irredeemable paper money, sometimes called Federal Reserve notes. This paper is redeemable in nothing but more paper, and is not substance nor representative of substance. The Federal Reserve note is nothing, has no power or capacity whatsoever. Federal Reserve notes were not an attempt to make dollars. They're not dollars. They're private money. United States versus Bilknard, 14 Wall 457. They are, in fact, registered bearer bonds, and as such, small change for United States bonds. Not being a property in possession, they are not dollars. Federal Reserve notes are not even convertible to property anymore. On the other hand, the standard gold dollar is or was property, allodium. Here's your tie, allodio, land, and allodium, dollars, gold, substance. You know, money has to have substance, or it's nothing. In possession, and is or was substance at law and usable in payment of debts. Not tender of debts, but payment of debts, rather than payment for debts. Big difference here between a payment of a debt and a payment for a debt. You know what these people are doing? They're taxing evidence of debt. You can't tax an evidence of debt. A Federal Reserve note is not substance. In fact, it's the evidence of debt. And so here you've got people using bills of exchange, which are evidences of debt, with which to go out and buy, sell, and trade with. What a renvoyé that is. Property is defined as the sole and despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe. The right to possess, use, etc. That comes from Bouvier's Law Dictionary. I think that's the 1914 edition, page 2750. In other words, then, property is something that you own to the exclusion of every and anybody else. Absolutely no one has any claim upon whatever it is you're claiming as property. You claim to own a house? Well, what happens if you don't pay the property taxes or the mortgage? Don't you see what happens? And even if you claim to own the house free and clear, you know, a lot of people do that. They have no mortgage. They're still paying property tax on it, aren't they? Well, if you're paying property tax on it, you don't own it. The government owns the land, and if you don't pay it like a good feudal serf, then the government will throw you off the land and put some other slave on it. We'll talk about land, and we're going to have Neelis Cook do that. Neelis is more of an expert in land than I am. He just recently claimed he and his two brothers, 58,000 acres of public land. That's correct. You know, you can claim public land, always have been able to claim public land. But merchants and traders in equity can't claim public land. Corporate capacity can't claim public land. Merchants and traders at law can claim public land. And so now we've degenerated to a position that slaves cannot go out and claim what's theirs. That public land is public land administered by government. It's not owned by government. Government has no title to the public lands. Government has title to and ownership of docks, forts, and yards, and things like that. Hunters Point Naval Shipyard is owned by the federal government, and they have title to it. So Neelis will get into that in more detail, and when we get through with that lesson, I think you'll have a better grasp of what your service to government is all about. We have all degenerated into this service to our government. And we owe specific performance to our government. And that national debt that you're looking at is the culmination of the master-servant relationship. And when you go to Scripture, what do you find? The servant, that is the debtor, is servant to the lender. And who's the lender? The Federal Reserve System. So the Federal Reserve System is the master, we're the debtors, we're the servants of that Federal Reserve System. And that's why we've been divorced from our land, and that's why we're feudal serfs on our land. That's the bad news. Now, the good news is you don't have to stay that way. You can change your status anytime you'd like to. But to change your status is going to require that you become a responsible citizen again with duties and capacities. You see, now you're incapacitated, and you're going to become a person with capacity. Well, down here at the, let's see, I'm on page 3, about halfway down, where it says standard gold dollars, being absolute property in possession, are actually portable lands, inasmuch as they vest the owner with full legal and equitable rights and interests and are allodial property. You convert land into gold and silver, and you have absolute despotic ownership of that land and that property. If you're the absolute owner and sovereign over that land or property, then it can't be taxed. Sovereigns don't pay taxes. Sovereigns impose taxes. Sovereigns don't obey law. Sovereigns create law. However, property is further defined into property in possession or choses in action, which are in effect equitable right of recovery. Okay? Now, you know, some of these terms that you're listening to here are strange and foreign. And you need to take Bouvier's Law Dictionary here, and you need to look up those terms, and you need to learn and understand them. Because in the courtroom, it's a battle of words. And you're in that courtroom to explain and to expound your position. And that judge, being ignorant, will begin to ask you questions and make you defend your position. And if you can't defend your position and explain the law, you can't stop his mouth. You know, a good parliamentarian is able, because he knows his position, to stop the mouths of those fools who would want to argue with him. And that's where you've got to go. From where you are now, you've got to get to the position where you can stop the mouths of these babbling fools. The truth that there are no dollars in circulation today becomes apparent when we define choses as an action. They are a right to receive without action. Bouvier, page 483, I believe that's also 1914 edition. In order to properly explain this, a distinction must be made between the security of the evidence of the debt and the thing, the substance that is due. A deed, a bill of exchange, or promissory note may be in the possession of the owner, but the money or damage due on them are no less choses in action. This distinction must be kept in mind. The choses in action are the money damages or the thing owing. The bond or the note is but the evidence of the thing that's owing. You know, you got a $10 bill in your pocket. That's the evidence that the Federal Reserve owes you $10. But it's not the $10. And when you're in there on that courtroom floor, we're talking about the evidence of a claim or debt, not the debt itself. And so we want to get to a place where we have gold and silver convertible to land so that we can get back to our common law. That's what we really need to do. And in the interim, we need to disclaim the equity that has been foisted off upon us. And the reason that they're bringing us into administrative law courts and this gigantic explosion of administrative law and rules and regulations upon citizens is the result of the loss of our allodial title to our land. We are now feudal serfs on the land. And as long as we're feudal serfs on the land, then the Federal Reserve has every right to regulate and govern and administer all of these rules and regulations to protect their property. Now you're going to say, well, how did the Federal Reserve steal our property? They didn't. You gave it to them. You gave it to them in 1933. They said, come line up at the doors of the bank and give us your gold and silver and we will give you paper. And all you people went out there and did that. I'd like to see somebody come along and say, now all you good people out there, bring all of your furniture down and stack it up outside the door and we'll give you a warehouse receipt. And now you can go home and sit down on your receipt. And you can go home and cook on your receipts. You see how insane that was? You know, these merchants of deceit who have been spreading paper money started at the Tower of Babel. This baloney of paper money and soft currency has been going on for thousands of years. And the people have been gullible for thousands of years, and people like John Law and Nimrod and numerous other Old Testament and New Testament and modern prophets of soft currency and paper money have been spreading that get rich quick and here's how to make money by going into debt. That kind of baloney has been with us forever. And as long as we want to fall for it, we will always be slaves. And it's just that simple. No big mystery about it. There can, in the nature of things, I'm down at the bottom here, close to the bottom of page 3, there can, in the nature of things, be no possession on a thing which lies merely in action. First National Bank versus Holland. So the Supreme Court understands money, friends. You take Article 1, Section 10 to the Supreme Court and they'll explain to you money. They've been explaining the income tax and money for the last nearly 100 years. But the problem is we citizens don't understand it, and we listen to our newspapers, we listen to Dan Rather and Walter Crankcase and all of these commentators who are controlled by the bankers and Time Life and all of the media, and they tell us what we want and what we ought to have. How many editorials do you see where it says, and the people won't sit still for these drunk drivers? It's time for action, and the people are demanding action, that these drunk drivers be driven from our highway. Now, that's what my newspaper tells me. I don't know about yours. I'm not demanding that those drunk drivers be expunged from the highway. I don't care if a guy drives down the road drunk. Doesn't bother me a bit. Not a bit. In fact, I'd rather have drunks on the road. Do you know that less people are killed by drunk drivers than by sober drivers? That's a fact. Explained that to you earlier. I don't want to be killed by a drunk driver, but I don't want to be killed by a sober driver either. And especially those sober drivers with brown eyes and brown hair. Boy, you've got to watch out for those sober drivers. Boy, they're a real threat on the roads. Bottom of page 3. And as the court's ability to order a fine paid, boy, there's a statement. Here's your jurisdiction. You're in the court, and the court's going to order you to pay this fine. Now, how are you going to do that? I laugh at judges. You know, sometimes I'll go in the courtroom and say, how'd you want me to pay that? I want you to pay it with money. What is money? Now, Mr. Gordon, we don't want to get involved in one of these long diatribes here on the money issue. Why not? I'll be happy to pay you. You just tell me how I can do that. It should be interesting to note, in the absence of fraudulent transfer or other such fraud as would be positively or would positively impede an action at law, the proceeding in garnishment or equity will not subject the chosen action of the debtor to the payment of his debts. Here's a Supreme Court case. You can't subject the debtor to the payment of his debts unless he's got the substance with which to pay it. It is obvious that the paper currency here in question and that is contemplated by this court as payment of a fine are in fact in operation of the law. But evidences of chosen action, the difference between the two species of property are carefully explained in Knox versus Lee. Now here's a quotation from the Supreme Court, 12 Wall 522, of how this chosen action works. We will notice briefly an argument presented in support of the position that the unit of money value must possess intrinsic value. The argument is derived from assimilating the constitutional provision respecting a standard of weights and measures to that conferring the power to coin money and regulate the value. It is said, there can be no standard of value which has no value itself. This is a question foreign to the subject before us. The legal tender acts do not attempt to make proper a standard of value. We do not rest their validity upon the assertion that their emission is coinage or any regulation of the value of money, nor do we assert that Congress can make anything that has no value money. The court says the Congress cannot make anything money that has no value. What we do assert is that Congress has power to enact that a government's promises to pay money for the time being equivalent in value to the representative of value determined in the Coinage Act. Yeah, the Congress can say, I'm going to give you this piece of paper. In 10 years from now, you can come get gold and silver for it. But they can't create fiat money. And they haven't. Congress isn't issuing fiat money. That's Federal Reserve money that you're using out there. That's private money. Hell, you might as well go out here and get monopoly money and go buy, sell, and trade. You know, there's trade groups all over the country, you know, and they're called units. You probably maybe even belong to one of these exchange clubs of some kind where businessmen barter back and forth. And what do they use? Well, they use what's called exchange credits, or they'll hang some other label or value on it. And they say, well, this is equal to the value of $1. Baloney. It's equal to the value of a Federal Reserve note, which is nothing more than a commodity in the world market, And it's like copper or gold or silver or any other commodity, potatoes, wheat, honey, beans, and it fluctuates in value with supply and demand. The more Federal Reserve notes that are floating around, the less it's worth. And the less there are, the greater its value. So, it is thus clear, and we're in the middle of page 4 here, that a promise of delivery is not delivery, nor upon national currency even meant to be. And there's a Supreme Court quote for you from Milan versus United States. For more on this subject, see Knox versus Lee. Here's a couple of cases for you to research and shepherdize. Go down to your local law library and read these 2 cases. You want to get a little more understanding about money. No one supposes that these government certificates are never to be paid, that the day of specie payments is never to return, and it matters not in what form they're issued. The principle is still the same. Instead of certificates, they may be treasury notes or paper in any other form, and their payment may not be made directly in coin, but they may be first convertible into government bonds or other government securities. Through whatever changes they may pass, their ultimate destiny is to be paid. And those Federal Reserve notes will be paid. They probably won't be paid to you. It'll probably be paid to some international banker over in Brussels or down in South Africa. It should be clear that money is a substance and not a promise, though the promise may be compelled of acceptance, and that's what happened on June 5th, 1933. You see, up until that time, a man came to you and said, I'm going to pay you, Sam, and here's the $20 that I owe you. You'd tell him, I want $20 in substance. I gave you potatoes and I want gold. But with HJR 192, the world changed. At that point in time, the merchants of paper fraud came along, got through the Congress, and nobody squealed or squirmed about it. Here was this direct violation of Article 1, Section 10, and compelled the payment. It compelled the acceptance. You know, now you came to me and said, okay, George, I'm going to give you this $20 bill. This is a promise to pay. It never was the substance. You already had my potatoes. And now, sanctioned by the government and law, you could now give me a piece of paper and say at some future date, I'm going to pay this. So I took that fraud and I looked around and I said, I'm going to pass this off on that guy. And from that day to this, that's all we've been doing is passing these frauds off. The only thing that makes that $20 Federal Reserve note of any value to you is you're pretty secure in the knowledge that you can take it down to Safeway or Kmart or somebody and you can pass it off to them and they'll pass it off to somebody else. Confidence. That's all that you've got in money. It's a confidence game. Such was the law in the general federal common law at that during the reign of Swift versus Tyson, which lasted until 1938, when the Erie Railroad decision and subsequent decisions expelled the law merchant from the federal common law. There is no general federal common law. The common law now resides in the states, which effectively destroyed the 7th Amendment to the Constitution of the United States and paved the way for the reign of irredeemable paper. Now, we didn't get irredeemable paper right away. You see, these guys, they come in softly and quietly, and little by little, a little chink here and a little chink there in the dike, until it starts the flood coming through, or the little trickle of water coming through, and now what we have is a flood of bureaucracy and regulation and rules that come down on us because we're nothing but a bunch of mere serfs. We have no rights. Paper, redeemable in nothing but more paper, finally became a full reality on March 18, 1968, exclusively on the federal level through Public Law 90-269. Yet Article 1, Section 10, Clause 1 of the Federal Constitution remains in effect. The Erie Railroad case decision could not destroy the common law. It's replaced it. It's changed it all right, but it did not destroy it. You know, the common law of the states founded and grounded upon substantive allodial titles in real property. You can stop paying property tax, friends. You can get off of this bandwagon of the international bankers anytime you want to. We're going to show you as time goes on how this allodial or allodium, as we call it, isn't a word that was coined by George Gordon and that you can't find in a law dictionary. It's true that the government would like you to believe that you have to pay taxes on your land, but that's not true, and we know of land that's been taken off the tax rolls, and you can take it off the tax rolls if you want to learn how. The best it could achieve were the conclusions or the compulsions of record in Milan versus United States. Nor can the courts of the 4th Judicial District, that's our judicial district, magistrates or prosecuting attorneys work in collusion with the king's agents, that's the policemen, to destroy the common law of the several states in substantive allodial titles. Land titles in the state of Idaho, as in all states of this union, once glorious and free, are allodial and substantive and not feudal and contemplative. It isn't something that we're contemplating that we think we'll get. They're here. It's substance. That land is out there. It's just that the Bank of Idaho owns title to it, and you have an equitable interest. We've got to reverse that. You own that land free and clear. Let's get out of debt, friends, and let's get our substance back. We can't have gold and silver until we have responsibility in our common law, and we get that by demanding it. We've got to be that belligerent claimant. There's no paramount overlord in any instance. The meaning of this should be known to the learned courts as in all our land, or in all of our law. Fundamental property consists in lands and goods as distinguished from franchises, jurisdictional powers, and fiscal immunities or other immunities derived from some civil authority that is not beholden to the people of the Union. All right, now, I just go on to show in the rest of this document how in the state of Idaho, because of my status as a merchant and trader at the common law, that my argument is that you lack the effective remedy. The court cannot compel me to discharge this fine that it's going to impose upon me in anything but lawful money, and the state of Idaho doesn't have any, and I don't have any, and they demand that I pay this in lawful money, and there is none. So the courts of this country, our contention is that there isn't a court in the United States of America that can compel specific performance in the payment of a fine in any way, shape, or form in anything less than gold or silver. A dollar, friend, is 412.5 grains of silver, or 1/42nd troy ounce of gold. The very definition of a dollar is that amount. You can't have a dollar's worth of glass or water or beer or anything else. A dollar can only be measured in gold and silver. All right, that being the case, let's take a look then at the next issue. Now remember, we talked about status early on, and I've got rights, jurisdiction brief, memorandum of law here. Let's take up this next one here called jurisdiction brief, status in support of demand for dismissal. Now we've brought in money as a supporting argument. Now let's take status, and let's show you how status then becomes an argument in support of our jurisdictional argument for dismissal.